Am I live or what? No. I'm not? No. I'm gonna let it sit. Hold on a second. Let me hang up for a second. Am I here? Because I'm not seeing myself here. Let me see. I can't believe this mess. What? All right. Y'all say I'm here. For some reason, I don't see myself on YouTube. But I thank y'all for waiting. I can't believe this. It's been almost 30 minutes. And I seen stuff in here about, excuse me, y'all. Fee schedule. Okay. All right, William, you described my shirt. This is crazy. I don't believe it. Well, I'm glad y'all can see me because in YouTube, I can't see myself yet. So, and it's not my computer. None of that. I just don't understand it. Something strange is happening. So let me check my phone, y'all. All right. Thank you, Carol. Thank you. Let me see. Will y'all comments show up? You see that? Y'all see that? Y'all can hold on. Y'all can't blame Colin for that. I'm gonna tell him too. Oh, we see the comments. Okay. Oh, really? Thank you, Lone Wolf. People thought I was trying to make them wait on purpose. I do not get this. So I don't know if YouTube did some kind of upgrade. My software was acting weird, but it has never done that. So maybe it's something with YouTube. If Lone Wolf had the same issue, it's not our software. So this is gonna be strange. I'm gonna keep checking until it come in. But I really thank everyone for your patience with this. And these are the people I see that will stick with me. I really appreciate that. Because I actually have something for y'all tonight too to look at. Wait a minute, hold on. Oh, I see it. We in business now. We in business. Thank everyone for coming in. All right, we gotta get this party started. And also, I don't know if all the members are here, but they'll probably watch later. New members came while I was on vacation, and it was quite a few. So when I got back, I was just trying to catch up, and I'd rather name them in the live, but I've had a couple more since then. So for anybody who joined in the last 10 days of the membership, thank you. I appreciate it. I'm just trying to catch up. And Colin did help me out last week. So I really appreciated that. Let's see. Yeah, it's probably sovereign citizens. They messing with me and they messing with Lone Wolf. Huh? We don't appreciate that. So, all right. So tonight is going to be more of a pro se night. Actually, the first clip on here, let me think. The first clip on here, Lone Wolf shared it with me because while I'm waiting for court dates with these sovereign citizens, sometimes, I mean, a lot of times I have a lot of stuff, and then sometimes we got like a gray area or like a period where you're just waiting for them to go to court. So I'm constantly researching to make sure court dates doesn't change, and sometimes they do because suppose I had a couple last week and the dates change. So I can't help that. So I was going to put something in the comments tonight. If y'all don't mind a little bit of pro se stuff, because sovereign citizens are pro se, they just on it on a more professional level, but unprofessional because it doesn't work. But I got a surprise for y'all tonight. It was worth the wait, not for the content. I'm gonna go ahead and give you the spoiler alert. I got a new commercial for y'all in reference to this content, so it was worth the wait. All right, so yeah, we all sorted out. So we're gonna go ahead and get the video started. And once again, thank everybody for waiting. So let's do this.
Hello? I'm sorry, Your Honor, I couldn't hear. Good afternoon, Your Honor. Nijad Mihana, appearing on behalf of Miss Whitmer, P59371.
Miss Whitmer, could you please state your name for the record?
It's Tamara Whitmer.
Okay, and today is the date and time set for our probable cause conference. It's being conducted by Zoom. Do you give Zoom consent for this hearing on behalf of your client counsel?
Well, Judge, I suppose the first thing we should address is my client does not wish to have an attorney and she wants to represent herself.
All right. Ms. Whitmer, do you understand that you have the right to have an attorney present if you cannot afford one, won't be appointed to represent you at public expense? Do you understand that?
Yes.
Knowing that, do you wish to waive your right to have an attorney?
Yes.
Do you also understand that when you represent yourself, that you are held to the same standard as an attorney, which means you are required to know the rules of evidence, the rules of procedure, you are to know how to conduct yourself in court, etc. Do you understand that you're still held to the same standard as an attorney?
Yes.
And you understand that even attorneys who have been through law school and been through college and have had numerous years of practice, that sometimes they encounter situations and legal issues that they have to research and question, etc. And knowing that they still have to do that, and you not being an attorney, you still want to represent yourself.
Yes.
You're positive.
Now you hear that? This person's pro se, but it sounds just like the sovereign citizens, except they're not going to do the extra arguments.
Yes.
Okay. Counsel, would you mind just being on standby just to make sure I do everything right?
There was a pro tem judge in on the day of this. I think Lone Wolf actually watched it. Well, I watched it too afterwards, but yeah, I think she was out that day. So Lone Wolf, if there's anything you want to speak up on, I'll put it on the screen.
Yeah.
Thank you. All right, so today's the date and time set for our probable cause conference. It's being conducted by Zoom. Ms. Whitmer, do you agree to appear by Zoom?
Yes.
Okay, how do you wish to proceed?
Not guilty.
Okay, a not guilty plea has already been entered on your behalf. See, this is what I'm talking about. You're expected to know how to answer that question. So what do you wish to do today?
Tell my side of the story.
Okay. So that typically happens at a trial. So now, what would you like to do?
Take it to trial because I don't want to do 2 years.
Okay, but this is a felony case, so you can't just go right to trial. There's certain procedures in place that you have to decide whether or not you wish to move forward with. I'm not going to hold your hand and babysit you and teach you the law because I don't have time. So you want to represent yourself, so tell me what you would like to do. If you don't know, then I trust or I'm advising you to speak to this attorney who does know.
I'm not taking his help.
We can't talk at the same time. he can present you the options and then you can tell him what you want to do.
No, thank you.
Okay. Do you want to have a preliminary examination in this case?
Meaning,
Oh, this is a PCC. Okay. I'm not going to explain it to you. You don't know what an exam is? So how do you know if you want it or not?
I don't want an attorney.
Okay, but it's clear to me that you don't know how to represent yourself because you can't answer the fundamental, simple, basic question of how do you wish to proceed?
I told you, I'm not pleading guilty to it.
Nobody's asking you to.
No one's mental. I'm not going to pay the state. I already have government. I already have corruption reporting
Okay.
by law enforcement, by the way. I have harassment already reported. That's what this is over.
Here are your options. You can either have this matter set for a preliminary examination, or you can waive your preliminary examination, have this bound over to Third Circuit Court. Do you know what a preliminary examination is?
No.
A preliminary examination looks a lot like a trial. The prosecutor comes into the courtroom and he or she will call witnesses to the stand. You or your attorney will be given an opportunity to cross-examine or confront those witnesses. The only difference between a preliminary examination and a trial is that the prosecutor has a burden of proof of showing by a probable cause standard that there is a sufficient basis for the charges. Meaning, in other words, the prosecutor has to show that there was a crime that was probably committed in either Wyandotte or Riverview and that you were the individual who probably committed it. That's all they have to show. The court will not consider defenses. It's just to make sure that there is a sufficient factual basis to allow this case to move forward to the next level of in the judicial system, which would be circuit court.
Well, I just saw what you put up there, Lone Wolf. So she think the government is after her. And then William, I forgot to do that. Some kind of way I need to take care of that. I don't know how, but I don't have to do it. But these are pro se's. A lot of times, not too many people interested in them. But yeah, thanks to what else you got? And she letting us yeah. She sure did.
Knowing that, do you wish to move forward with a preliminary examination or do you wish to waive?
Waive.
Counsel? Is he there? I'm telling he left. Oh, there he
Right
is.
here, Judge.
I just had a heart attack.
The issue, Judge, is that I don't have discovery, and I think the prosecution was going to send it to me this morning. I don't know if I have it yet. And so I don't have the discovery to be able to assist her with what she would do, and she does not want to talk to me, so.
Well, I guess now I'm having concerns about competency.
Me too.
Any objection to just referring this for a competency review?
My only concern is I didn't get a chance to be able to flush that out from her. And
Why don't you, can you place on the record what your position would be? It sounds like she doesn't want to talk to you.
that's correct, Judge. So I wanted to explore with her the issue of competency referral and what it would entail and so forth, given the fact that she's locked up as well. But I couldn't do any of that. And when I tried to inquire, he wouldn't let me. And she actually,
Hey, I'm gonna stop for a second. Yeah, have y'all noticed the girl on the bottom? She's looking like, what the heck is going on? She's making all kinds of faces down there.
she denied that she has any issues and said, "Why are you asking me the questions? You're not my attorney."
Okay. Do you know if we need a stipulation from the prosecutor to obtain a competency referral? Can the court do it sua sponte?
I think the court can do it. Either party can ask for it, and including the judge can also send the referral if they think there is a need.
Court is going to refer this matter for a competency evaluation. bond is continued. Do you usually set a competency hearing about 90 days out, Madam Court Reporter?
You should do a review about 3 months. So
Court
Those things take a long time when they schedule those competency hearings. They take a while.
will set a competency hearing. Will bring us to August. Can I get a date in August? You have one right there?
yes, and August 28th.
Then would that be 9 a.m.?
We can do that.
All right, let's set this for a competency hearing, August 28th at 9 a.m. by Zoom.
Okay, sounds good, Your Honor.
Anything else for this record?
No, Your Honor, thank you.
Thank you. That will conclude this hearing.
Are you a pro se defendant feeling overwhelmed by the legal system? Don't just represent yourself. Transform yourself with Pro Se to Sovereign, the ultimate coaching service designed to stretch your case for months or even years. Our proven system will teach you how to flood the court with 500-page jurisdictional challenges, challenge the judge's oath of office, declare yourself a secured party creditor, and reject all corporate authority by saying, "I do not consent." Confuse the court, frustrate the prosecutor, and delay justice indefinitely, all while asserting your status as a private living soul of the land. Don't plead guilty, plead sovereign. Call 1-888-DRAG-IT-OUT to get your service started today. From Pro Se to Sovereign, you may not win the case, but you'll never give up your time. Live sovereign, live free. Okay. I hope you enjoyed that one. For those of you who waited, so there you go. I hope you enjoyed the new commercial that's on deck here. And yeah. Now we're ready to go to the next to the next hearing. Thanks, William. Appreciate it. The next hearing, I believe, is Judge Wolf. It should be. Oh, yeah. Yeah, so I think that the next hearing is Judge Wolf. Actually, Colin put me on with this one. It's a pro se guy in there, but the way it start off, it sounds like he's straight sovereign. But let's check this out. Maybe you've seen it, maybe you haven't, but let's just go with it. Let's go.
All right, Mr. Vaughn, we're here today because you have filed a number of different motions, and I want to address those motions with you, give you an opportunity to be heard. So if you want to come to the podium, since you are representing yourself, I will deal with each of those motions. First of all, let me advise you that in April of this year, you filed that you...
You got to ask me in the chat. Hey, Lone Wolf, y'all related?
Got a notice stating it was to the judge of record, stating that on the 15th day of April 2025, I have some concerns that I wish to speak to you about before I file papers in your court. I'm letting you know this isn't a request for advice. It concerns actions by your staff of the courts and yourself. With the utmost respect, I write this ex parte letter. If we can meet in private, I will. If I can't meet in private, I'll file it publicly and the order will be noticed. I could not speak with you privately because of the rules of conduct for judges. So the first notice or first motion that you have filed has been a request for a criminal record, and states that you're requesting the courts to move the state to furnish the defendant with a copy of the prior criminal record per Rule 16 of Discovery and Inspection. Rules of Criminal Procedure. If I understand correctly, you're asking for a copy of your criminal record?
Yes, all them requests, the motion discovery is supposed to provide all that anyway, so that'll summing up half the motions. I mistakenly filed them separately.
That's fine.
Some of them.
You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself. So I'm going to order that all of the evidence in Mr. Vaughn's case needs to be put into written form, hard copies, and he needs to be provided with that.
Judge, the problem with that is going to be that there are videos from his arrest. One of his charges is retaliation for past action. And so there are videos from the officers in the jail at that time. And that's going to be one of the largest problems in providing that to him.
No, sir. That's not a problem. I filed a civil suit years ago. They provided me with the DVD, and it was my issue to deal with after that. And they allowed me to go into the office privately, view my own case, to fight my own case before, so that is not an issue.
Sounds like he's got it solved.
Okay.
You provide him with a DVD or a video on a compact disc, he'll access it as he needs to at the jail.
Okay.
All right, when is this gonna be? Because I've been doing some of this since 2021. I'm tired of coming here looking at y'all. Like, this is going on for a minute. This is getting ridiculous. This is my first, I still ain't got a motion yet.
A motion.
I ain't got a motion yet. All the attorneys I had, all the public defenders I've had, nobody have provided me with nothing yet.
Okay. Well, I'm going to deal with all of that today because you're going to get written discovery. You're going to get a copy of any videos so that you can look at them yourself. How long will it take for him to be allowed? His trial date's in September. How long will it take to get the hard copies of the written discovery? All right. We'll have it within.
Ben, she should have it today.
We'll have it within 10 days. Okay? You have a second motion, which is a motion to remove your counsel. Mr. Spratt was appointed as what is generally referred to as elbow counsel. You want to represent yourself, and I've granted you that opportunity. I've also appointed Mr. Spratt to assist you in representing yourself so that he can, because you don't understand, I assume, the rules of evidence and the rules of criminal procedure fully as if you had been to law school. So having a lawyer who can assist you in making objections to evidence, for example, and things, that's the reason that you have elbow counsel. So Mr. Spratt was appointed, and he has tried a number of criminal cases, is very competent as an attorney, and that's the reason. So why do you want to dismiss your elbow counsel or your assistant
For
counsel?
one, the court doesn't respect the fact I'm pro se. They prefer to talk to him instead of to me. And anything should come through me first. He's an assistant. For two, Mr. Spratt since December has had a sickness or illness going on, which is on record in Humphreys County Jail, where he never could show up out there. I called 2 or 3 times. I should have had the motion discovery he just handed me.
All right. Well, that's part of life, that people have illnesses and sickness. I am going.
Not for a month and a half. I'm sorry, sir. Excuse me, but not for a month and a half. I mean, he ain't able to help me.
Well, I'm of the opinion that Mr. Spratt is able to help you with this because he is only elbow counsel. You're representing yourself.
William, thank you very much. Let's say an open cardboard box with the word unboxing, huh? Thanks. Wait, I look like I need caffeine? I could use some though. Yeah, hook me up. Thank you. Thank you.
I will order that the discovery and motions that are filed in his court need to be sent directly to Mr. Vaughn rather than a copy to Mr. Spratt directly to Mr. Vaughn so that he gets a copy without having to wait for his co-counsel. No, you just have to mail it to him and he'll receive it. So I'm denying at this time your motion to remove counsel because I think it's important for you to have someone at trial to help you with that. I've ruled you're going to have access to the discovery directly. You're representing yourself. Mr. Spratt's role is as elbow counsel to assist you in, the trial itself
Well, what about the fact that he couldn't even come to Waverly? How you gonna get to Decatur?
I'm going to appoint Mr. Spratt. You want to address any of that, Mr. Spratt?
I will, Your Honor. I'm not sure of what illness I had for a long time. I was sick back during the holidays. I did just hand Mr. Vaughn his discovery in case number 2021 CR 462. My understanding is the state wishes to proceed to trial in 2022 CR 336. There is no discovery that's been provided to me electronically for that case. When I did finally feel better and go to see Mr. Vaughn, he had been transported to West Tennessee, and I just simply have not been able to make it down there with my schedule. But he does have the discovery, or the written discovery. I did not give him the electronic discovery today because of reasons which he's now clarified.
Well, I told you that too when we talked on the phone. Me and you done been over that.
Let me hear from Mr. Spratt. This is not a time for you and him to discuss.
I mean, I'd be happy to mail him a DVD of anything electronic for that case that I have. I only have discovery for one case.
He needs the discovery for the case he's going to trial on, so let's make sure that that discovery is provided to him. Ms. Bryson says she can provide it to him next week, so I would order that she provide that by mail to Mr. Vaughn next week, as he wants to have it directly, and then a copy to you, Mr. Spratt. All right. I am denying your motion to discharge Mr. Spratt from being your elbow counsel for the reasons I've stated on the record. Another motion you have filed is a demand for speedy trial. Your trial date is in September, which is the next term of court that I have. It's available, and for that reason, I believe that that complies with the request for speedy trial that was filed. It is the first available date that we can put into play according to our rotation of judges and our schedule that we have. That is the first available day. The September date does, in my opinion, comply with your request. Case won't be continued, so we'll need to make sure that it is ready for trial on that day. The remaining motions that you have filed are all motions for discovery, which I think you had mentioned before, and I think we've now addressed that. So he's set for trial on September the 19th, is that correct? That needs to be shown to be first on the docket.
Excuse me, sir.
Docket, so that we'll go to trial. And let me address this. You filed a motion to recuse, notice of recusal or request for the master clerk, and you're asking to recuse or to somehow recuse the clerk of the court, and there is no basis that you have no basis, you have no standing under the law to ask this court to disqualify the clerk of the court. I understand your reasons for why you say that, and I have addressed the problems that you're saying you've had thus far with receiving copies of things, and that's going to be mailed directly to you. The court file will have it reflected that you are to receive all of those as lead counsel in your case, and I am not of the opinion that you have a basis in law or in fact to remove or ask for a recusal of the circuit court clerk. So that motion is denied.
You would think the sovereign citizens would go this route. Excuse me. That's a new one to me too. I wonder who else he wants to recuse. Eh?
In addition to that, you had a motion to recuse the court recorder, and again, I have no idea why you would allege that there is a reason for that, but
So if you recuse the court recorder, how's it going to get on the record? Okay, I'll take that.
I don't find any basis for removal or that you have standing to remove the court reporter. She worked for me, and under that basis, I don't find there's any reason
Well, then
remove
me and
that.
you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork?
Did he hear what I just said or something?
How am I going to get a fair trial here?
You're going to get a fair trial because you're going to be tried according to the law and the facts. And a jury of impartial people who know nothing about your case will make the decision.
So if I want to make an appeal and she ain't recording it, how are we going to do that?
She will be recording it if it is a felony case. Yeah, there are certain times when the cases are not recorded, or if we're on break, it's not recorded, but
Well, we wasn't on break because, look, I just walked out the courtroom and I said something. After we went on break, you said omitted. And she said, well, I ain't got to omit it. She said I wasn't recording no way. So how can I appeal something if y'all taking it out of the record without me being present during the proceedings?
first of all, I don't recall any such thing that
Well,
you're
go back and
referring
look at the
to.
video.
I'm not required to go back and look at the video, Mr. Vaughn. I'm required to make decisions based upon whether or not you have standing for the motions that you filed. In my opinion, you don't have any standing to ask this court to discharge our court reporter or our clerk. And for that reason, I'm denying those two motions.
Well, recuse yourself because you're not doing it. You're not doing it.
And there's no basis for me to recuse myself.
Is this being recorded?
If you want to file a motion for me to recuse myself, then I will deal with that under Rule 10, and then I will address
I'm familiar
that.
with all the rules. Y'all sit me in jail long enough. Best believe I read them.
All right. Anything else?
You see how he asked, is it being recorded? Would you want to get rid of the recorder? Yeah, all right.
No, that's all.
All right. Thank you.
Briefly, if I may, when would Mr. Vaughn be transported up for this trial? Because the trial that
I
I
done put
mentioned,
in 3 motions for that. That ain't getting heard either.
I'm just asking the court, because the trial that I have in Davidson County that I mentioned in the earlier matter is the first of that week. We do not expect that to be a 5-day trial. But I'm wondering if I'd be able to meet with him to strategize at all for this trial beforehand, other than Thursday, the 18th.
We can order that he be transported earlier if you just tell me when you want. The 17th?
No, I like my cigarettes where I'm at. I don't need his assistance.
Okay, well, that'd be fine, Your Honor.
That's fine with us.
Yes, sir.
All right. Thank you, Mr. Vaughn. You step back.
Oh, leaving the room.
All right. I believe now that we've dealt with Mr. Fan, that concludes our business for today.
All right, y'all think that was interesting or what? This guy put in motions to recuse everybody. Don't let the sovereign citizens find that out. Hold on, what's that? Quit smoking cigarettes. I'm trying to remember what the next one is. I have 2 more. I'm just gonna play it. I meant to make notes, but I had trouble tonight, which y'all forgiving me for and not charging me a fee schedule. All right, so here we go with the next one. I'll know as soon as it's up.
In their own breakout. All right.
Oh, this one. Yeah, this is gonna be interesting. I'm just gonna let it play. You got to hear what's going on with this one, okay? But this is a true reason why pro se doesn't work. When you don't know, the courts don't know how things work. Here's a good example right here.
So case 1 is with the mediator at this point. Let's go to case number 2. Hazel Isaacson and Ed Stolarik. It's case number 39092. And all right, so Ms. Isaacson, we have you, and Mr. Berner is here. Apparently on behalf of Mr. Stolarik. So let me ask this question. I didn't see service in that matter. Do we have service?
Yes, Your Honor.
Ms. Isaacson, did you serve Mr. Stolarik with this
Yes, Your Honor.
documentation?
I served both through the mail. I have the receipt, and I also served through the Secretary of State. And I have both
Did you
proof.
file any of that service documentation with the court?
Okay. And just file it with the court?
So you haven't filed it yet with the court. Is that what you're saying?
That's correct. I have it right here.
All right. And let me ask you this question. Why did you serve Mr. Stolarik?
Because Mr. Stolarik is the individual who was in communication with us and was the decision maker for that we needed to remove things and telling us that we were owing money, and also who was putting our boathouse up for sale. He was the individual in charge. To my knowledge, he was the person who was in contact with the Board of Trustees.
All right, Mr. Berner, I'll hear from you just as to the preliminaries of the case.
Thank you, Your Honor. Mr. Stolarik is a board member of the Olympia Yacht Club, but he's not the registered agent. The service of the notice of small claim was provided to the Olympia Yacht Club via certified mail, but it was for the hearing that was previously set for March 21st, 2025. I had to call the court to see if there was another hearing, so that's why I'm here today. So service was not effective on the yacht club of the notice of small claim. And then, as Ms. Isaacson mentioned, this is a dispute over a boathouse, which is titled property. It's titled in the Isaacsons currently. It's tax assessed. It has a parcel number. So district court does not have jurisdiction under RCW 3.66.030. I have also tried to contact the Isaacsons via mail and phone calls, but they haven't returned my calls. I represent the Olympia Yacht Club. I've reached out to them multiple times, so be happy to talk with them. But I don't believe this matter is right to proceed today.
Your Honor, may I speak to that?
In a moment.
Yeah, in a moment. Thank you. Thank you very much, Michael. Oh, yeah, this is a chat of record. Whatever you put in the chat, it's going to be saved. So, yes, you are on the record, and I appreciate your super chat. Thank you. Thank you very much.
Let me ask this question. Has the sale of this boathouse actually occurred or not?
I have no knowledge. I have no access to the boathouse. They have the keys.
All right, I'm asking Mr. Berner.
Oh, I'm sorry.
It has not. Still titled in the Isaacsons' name.
All right, Ms. Isaacson, go ahead.
In November of last year, I hired Joel Peñar to help us try to mediate this situation. And this is the attorney that we were speaking to, so he's well aware of what's been going on. He also was informed by Joel. I informed the court last time we were here that this is the attorney who was informed about this small claims court, yet they didn't show up the last time, even though I had tried to get service 28 different times through a service company. I did get service finally through the Secretary of State, and Mr. Peñar had suggested I go through small claims in order to try and expedite this, because there was this attorney keeps increasing both the funds we owe, and there's no it doesn't even make sense what this attorney wants. So I can't move. I can't have access to the property. I can't make any moves until something is done. Even though the property's in my name, I have no access to it.
All right. Two problems, Ms. Isaacson, with this.
Okay, Ambulance, thank you for becoming a member. Thank you very much. I hope you enjoy yourself here, and check out the community chat so that you can get into the members chat. Okay, thank you very much. I appreciate it. Let's see.
First of all, your claim is for money damages here. You're claiming that at least as I read it, that the boathouse was sold for $25,000 and you're wanting some portion of that returned to you.
Trish, how you doing tonight? Okay, I got some stuff popping up through here. All right. I wonder if the chat's delayed. I'm going to double check if it is. It's something going on with YouTube tonight. But thanks for the 5 gifted memberships who went to Michael, Idaho, Math Girl, Crafty, Navy. That's it. Thank you very much. Thanks, Trish. I really appreciate you doing that. All right, let's yeah, I'm trying to see what's going on. Things are acting a little weird tonight.
Mr. Stolarik did not sell that property. He didn't have title to do that. So you're making him the defendant in this case, even though he may have spoken to you about this and so forth. He's not the proper party defendant in this case. Looks like it's the yacht club that's the appropriate party defendant in this case. So that's number one issue, that there's not been proper service on the yacht club, even though Mr. Berner is here on behalf of the yacht club today. Second issue is, what's the jurisdiction of this court in relation to the property that you're talking about? Mr. Berner makes a good point that this court only has limited jurisdiction in this matter, and for property that is owned with the title in this way, real property, so to speak, this court does not have jurisdiction in that matter. And he quoted the RCW that deals with that. It's RCW 3.66.030. Now, I can't, as the judge in this case, I can't decide to give you legal advice as to how to proceed with this thing further. But what I'm obliged to do at this point is to say that this court doesn't have jurisdiction in this matter for 2 reasons. Really, number one, the wrong party defendant is listed here. Mr. Stolarik is not the proper party defendant. And number two, this court doesn't have jurisdiction over this kind of case, so to speak, when you're talking about real property or what is considered real property. So I am going to have to agree with Mr. Berner to dismiss this case. Go ahead, Ms. Isaacson.
May I ask a question? I sued Mr. Stolarik on behalf of the Olympia Yacht Club. He is a board member of the trustees and would be responsible for decision-making of the club. And he did not show up. He just sent an attorney. That doesn't seem like it's proper within the court, but I don't say there's no attorneys that should be present in the court. In addition, it's not just a complete where we own the property. According to the Olympia Yacht Club, they lease it from the state of Washington. They lease the property, and then we purchase the property through them, and we only have access because they allow us to have access. So I don't understand if they have a lease, but we buy the property, what jurisdiction it would be under, because they're leasing through the state of Washington, and they're not following some of the rules of the state of Washington. So wouldn't it be this court that I could go through? Your Honor, my husband is available to help me. He's not an attorney, but he did go to law school and he's ill, but I can bring him in to maybe help clarify some of the things about our club. He is the part owner.
Here's
and
the
I'm still a
problem.
little overwhelmed
Ms.
by
Isaac-
the attorney.
Exactly.
Thanks, Your Honor.
Here's the problem, Ms. Isaacson.
Wait.
Mr. Stolaric is, as I say, not the proper party defendant in this case.
Your Honor.
He may be on the board of directors, but he didn't sell the property. He doesn't have the money. The property hasn't been sold. Much of what you're arguing about here in this case, hold on. Much of what you're arguing about here hasn't occurred yet. It hasn't been sold. And you're asking for money from something from a transaction that has not occurred. We're getting far afield, Ms. Isaacson, Mr. Isaacson, we're getting far afield in the merits of the case. We're not going to get to the merits of the case because this court doesn't have jurisdiction. There's small claims court, there's district court, there's superior court. Each of them have different levels of jurisdiction, matters that they're allowed to discuss and make decisions on.
Your Honor, may I speak, please? Your Honor, may I speak?
You have been, while I've been trying to speak.
I haven't spoken up about attorneys. He's misrepresented the case, Your Honor. I've been listening on my bed, upstairs to the attorney. He's misrepresented the facts. He's misrepresented the actual law that represents the situation here, Your Honor. It's not RCW, whatever he claimed. And also, Your Honor, I want to say something about just proper decorum. This is not trial by ambush. You don't bring an argument.
Going to represent you at.
Hey, hold on, everybody. There's a excuse me. There's an issue. So remember, those of you who was on here in the beginning with me, apparently there's another live that they're waiting on. I have to send them the link. So if you give me 1 second, this is terrible tonight. I don't know what's going on. Hold on. So I apologize, but I need to get them in here. Okay, everybody's still here, right? So there was another live or upcoming. It didn't go live, but a lot of people have been sitting in there. Let me see. Well, I think a lot of them left out, but they're coming in. They should be coming in now. Yeah, this was strange. I'm glad I had Lone Wolf as a reference to back this up tonight. So I need to delete that. My apologies, everybody, once again. Let me get rid of that because people are sitting in there. Okay, I guess, Wanda, were you in the other one? Yeah, there was a glitch tonight. So, I mean, y'all been with me for a while. This has never happened. So something was happening and I got Lone Wolf here. He said it happened to him the other night. So it might have been something with YouTube. I'm not sure.
Person who is in contact with the Board of Trustees.
Oh, so for those of you who came in, I guess you may have to go back to the beginning since I've already had people on here for a while. I'm sure y'all don't want me to start that over. Okay, thanks, Lone Wolf. Yeah, he said all weekend. This is the first time I've been live since I've been back off vacation. And it's been a mess tonight. And I'm sorry for the inconvenience once again, everybody. You know, it's not my fault. Okay. Yeah, so all right. I'm just gonna keep it moving for the ones that's been here. It's just been a really rough night tonight. Oh, if I accidentally took it back because I was getting messages from someone else saying that they were stuck in the stream and I wasn't there. Okay. Oh, thank you, Deathbag. What's up? Okay. I saw you had left a message when you became a member. I was out. I didn't get to respond. And in the beginning of this one, I said I was just welcoming all the members, including you. I remember exactly what you said to me directly, and I really appreciate that you like it here. So thank you very much. Okay, yeah, appreciate it. Appreciate it. Thank y'all. Thank y'all. I need caffeine and alcohol. All right, okay. All right, let me see where I'm picking up at now. Yeah, the Saul's all watching. All right, got you, man. Appreciate that. Yeah, hook me up.
All right, Mr. Berner, I'll hear from you just as to the preliminaries of the case.
Thank you, Your Honor. Mr. Stolarik is a board member of the Olympia Yacht Club, but he's not the registered agent. The service of the notice of small claim was provided to the Olympia Yacht Club via certified mail, but it was for the hearing that was previously set for March 21st, 2025. I had to call the court to see if there was another hearing, so that's why I'm here today. So service was not effective on the yacht club of the notice of small claim. And then as Ms. Isaacson mentioned, this is a dispute over a boathouse, which is titled property. It's titled in the Isaacsons currently. It's tax assessed. It has a parcel number. So district court does not have jurisdiction under RCW 3.66.030. I have also tried to contact the Isaacsons via mail and phone calls, but they haven't returned my calls. I represent the Olympia Yacht Club. I've reached out to them multiple times, so be happy to talk with them. But I don't believe this matter is right to proceed today.
Your Honor, may I speak to that?
In a moment, let me ask this question. Has the sale of this boathouse actually occurred or not?
I have no knowledge. I have no access to the boathouse. They have the keys.
All right, I'm asking Mr. Berner.
Oh, I'm sorry.
It has not. Still titled in the Isaacsons' name.
Thank you, Wanda.
All right, Ms. Isaacson, go ahead.
In November of last year, I hired Joel Peñar to help us try to mediate this situation. And this is the attorney that we were speaking to, so he's well aware of what's been going on. He also was informed by Joel. I informed the court last time we were here that this is the attorney who was informed about this small claims court, yet they didn't show up the last time, even though I had tried to get service 28 different times through a service company. I did get service finally through the Secretary of State, and Mr. Peñar had suggested I go through small claims in order to try and expedite this because there was this attorney keeps increasing both the funds we owe and there's no, it doesn't even make sense what this attorney wants. So I can't move. I can't have access to the property. I can't make any moves until something is done. Even though the property's in my name, I have no access to it.
All right. Two problems, Ms. Isaacson, with this. First of all, your claim is for money damages here. You're claiming that at least as I read it, that the boathouse was sold for $25,000 and you're wanting some portion of that returned to you. Mr. Stolarik did not sell that property. He didn't have title to do that. So you're making him the defendant in this case, even though he may have spoken to you about this and so forth. He's not the proper party defendant in this case. Looks like it's the yacht club that's the appropriate party defendant in this case. So that's number one issue, that there's not been proper service on the yacht club, even though Mr. Berner is here on behalf of the yacht club today. Second issue is, what's the jurisdiction of this court in relation to the property that you're talking about? Mr. Berner makes a good point that this court only has limited jurisdiction in this matter, and for property that is owned with the title in this way, real property, so to speak, this court does not have jurisdiction in that matter.
Carol, excuse me again. No, it's not repeating. I accidentally went back a little bit, and then some new people came in. So we probably went back about 7 or 8 minutes. So that's the reason why you may be hearing something again. So we're getting through this one. And I don't know who saw what, so I don't want to stop it at this point. So if you've seen this, you can be a little bit patient. We're going to the next hearing very shortly. Thank you. And
he quoted the RCW that deals with that. It's RCW 3.66.030. Now, I can't, as the judge in this case, I can't decide to give you legal advice as to how to proceed with this thing further. But what I'm obliged to do at this point is to say that this court doesn't have jurisdiction in this matter for two reasons. Really, number one, the wrong party defendant is listed here. Mr. Stolarik is not the proper party defendant. And number two, this court doesn't have jurisdiction over this kind of case, so to speak, when you're talking about real property or what is considered real property. So I am going to have to agree with Mr. Berner to dismiss this case. Go ahead, Ms. Isaacson.
May I ask a question? I sued Mr. Stolarik on behalf of the Olympia Yacht Club. He is a board member of the trustees and would be responsible for decision-making of the club. And he did not show up. He just sent an attorney. That doesn't seem like it's proper within the court, but I don't say there's no attorneys that should be present in the court. In addition, it's not just a complete where we own the property. According to the Olympia Yacht Club, they lease it from the state of Washington. They lease the property, and then we purchase the property through them, and we only have access because they allow us to have access. So I don't understand if they have a lease, but we buy the property, what jurisdiction it would be under, because they're leasing through the state of Washington, and they're not following some of the rules of the state of Washington. So wouldn't it be this court that I could go through? Your Honor, my husband is available to help me. He's not an attorney, but he did go to law school and he's ill, but I can bring him in to maybe help clarify some of the things about the club. He is the part owner.
Here's
and
the
I'm still a little
problem.
overwhelmed
Ms.
by the attorney.
Thanks, Your Honor.
Here's the problem, Ms. Isaacson.
Wait.
Mr. Stolaric is, as I say, not the proper party defendant in this case.
Your Honor,
He may be on the board of directors, but he didn't sell the property. He doesn't have the money. The property hasn't been sold. Much of what you're arguing about here in this case, hold on.
All right, I got a couple of things to address again real quick. Okay, Laura, let's see, Collins Chandler. Okay, I actually had Colin talk to me about something new. I think that YouTube did. I don't know what it is. I will investigate it after this live. He told me earlier. I didn't get a chance to look at that. This is my first live since I've been back, so I don't know what's going on with these crowns because he didn't know either. Second of all, those of you who are on my text live message, I just sent out another text to everyone that subscribed because some people may have was in the other one and couldn't get back into this one. So I resent the link. So if you got it, you can ignore it. But I want to make sure people was probably waiting and they didn't know where I was at. Oh, well, that's good because we was having fun in this chat too when I had to cut it. So yeah, appreciate that. Just trying not to keep interrupting, but I got to do it because we got problems tonight and I need to make sure everyone knows what's going on. Y'all know I'm real transparent about everything, and I don't want people left out that was trying to get in that are frustrated because they can't. Okay, yeah, appreciate that. Yeah, I was like, let me send it again. Okay, so we'll reset. I'm gonna look into whatever's going on with YouTube, but hopefully it don't affects us here. So let's keep going with this case with these with this woman. I've been so busy trying to make sure I take care of y'all. I haven't really been saying anything about the case, but this is clearly a reason why you need an attorney. She doesn't even know how to properly file it. And then her husband, who hasn't even graduated from law school, trying to say stuff to the judge, it's just ridiculous. So, okay, nothing wrong with that. I can't argue with the casino. I was there last week. All right. Okay, let's go. Finish this one up.
Much of what you're arguing about here hasn't occurred yet. It hasn't been sold. And you're asking for money from a transaction that has not occurred. We're getting far afield, Mr. Isaacson, we're getting far afield in the merits of the case. We're not going to get to the merits of the case because this court doesn't have jurisdiction. There's small claims court, there's district court, there's superior court. Each of them have different levels of jurisdiction, matters that they're allowed to discuss and make decisions on.
Yes.
Your Honor, may I speak, please? Your Honor, may I speak?
You have been while I've been trying to speak.
I haven't spoken up about attorneys. He's misrepresented the case, Your Honor. I've been listening on my bed, upstairs to the attorney. He's misrepresented the facts. He's misrepresented the actual law that represents the situation here, Your Honor. It's not RCW, whatever he claimed. And also, Your Honor, I want to say something about just proper decorum. This is not trial by ambush. You don't bring an RCW into a court and waylay some poor lady, my wife, who's not an attorney, without providing that to her so she can review the law and have a rebuttal that's appropriate. You can't do that. It's not proper. So I'm saying that you can't have an attorney in district court. One, you do have jurisdiction, Your Honor, and I can argue it very well if I can see the law. I can do it. You have jurisdiction. So what I would say is that if this attorney is able to sway the court and be persuasive, I would ask that this be continued so that I can go research the law, a proper rebuttal, because the reality of the property is this. The property literally is owned by the Olympia Yacht Club, and pursuant to their bylaws, we are allowed as an outside party, not a member of the yacht club yet, to make a purchase of such property, but only on approval of the Olympia Yacht Club board and their laws and bylaws. They are the party to this lawsuit. They got it. The whole argument of this lawsuit, Your Honor, is a breach of contract. The Olympia Board of Trustees got into a contract with me and my wife to purchase this property or sell it. We have all of that in our records. It's all in front of the court. The court has the jurisdiction to have a breach of contract claim, and also this court has jurisdiction to hear interference with contractual relations. Those are the issues before the court. The court we are arguing that the Olympia Yacht Club created this whole controversy, created this problem for us. We can show it by the facts, created a contract with us. We have all of the 4 prima facie elements for a breach of contract claim. They built a contract with us. Ed Stolark was the representative of the board for the creation of that contract. He is the one who has standing to this court. We have proven standing. We've proven jurisdiction. The attorney is speaking over Mrs. Isaacson and not allowing her to properly argue this case as if she were an attorney. That is not fair, and it's not what this district court was designed to do. We know this. So I'm asking that if the court would kindly allow us to get a continuance so that I can put all of what I just said into a properly articulated document with the proper exhibits. I'll be happy to do that, Your Honor. But my God, I've got liver disease. I'm on the UNOS patient list. I'm about to, it's been a rough winter, Your Honor. I will do my best to put that all together, but frankly, don't dismiss the case. I'll get 30 days to respond to the attorney. You do have jurisdiction. He is not properly doing this. He is the attorney who mucked this all up in the beginning, just like Mrs. Isaacson said. This literal attorney, has acted, in my opinion, in bad faith, and we have documentation for that, Your Honor. Please do not dismiss this case as misrepresentations of what is jurisdiction and what are the facts of the case and what is the justiciable issues in this case and who has standing and who has the right to bring the case before this court and also to ask for this court for proper relief. And all of that is here in this court. You have it, Your Honor. I can bring it before you and I can argue it properly. Please do not dismiss.
All right, Mr. Isaacson.
Yeah, he need to stop him because he rambling and he look like he having a temper tantrum and he doing hand movements almost like Denzel, but he messing it up. This guy doesn't. This guy's something else. I'm sure y'all going to say something about him in there, but he hasn't even graduated. I'm surprised the judge let him go that long because if he was in another court, he wouldn't have been allowed to speak like that.
Enough. I'm sorry that this is such a problem for you and it's upsetting you, but saying it over and over again doesn't make it so. What I'm finding is that Mr. Stolark is not the proper defendant in this case. The Olympia Yacht Club is. He doesn't own the property. He doesn't make all the decisions. The yacht club and the board of directors or whatever make those decisions. He doesn't. So it's not properly served on him. That's number one. And number two, I have real question as to whether or not this court has jurisdiction over the property. You can argue all you want about that. You can look at the statute as well. The burden is on you as a plaintiff when you're filing this to understand those things when you bring them forward. In a small claims court, all Mr. Berner has done is raise 2 legal issues, nothing about the facts or the merits of the case. One is service, second is jurisdiction of the court. It's appropriate in this instance on behalf of the Olympia Yacht Club, which has been improperly served, but is aware of the case, obviously from what you've told me, that you've had discussions with him in the past, that's fine. The yacht club still has to be properly served in order to be held to account by a court, whether it's this court district court or superior court. What I'm telling you is this court doesn't have the jurisdiction to do that. Number two. Number one being that Mr. Stolarek is not the proper defendant in this case. So I am going to dismiss this action. If you want to look at this further, Mr. Isaacson, and make your case, you can do that. But we're not going to continue this indefinitely. Apparently, this is the second effort at this case. Maybe the first had a problem with service. I don't know what the issue was there. I'm not looking into the merits of the case. I'm looking at the legal approaches to bringing this case in the first place. So that's it. We're finished with this. Okay?
How are you dismissing it? With prejudice or without?
Without. If you want to refile, go ahead. But
Thank you.
Your Honor.
remember the issues that
We
Mr.
do, Your
Berner
Honor.
has pointed out.
You made them very clear to us. Thank you, Your Honor.
Thank you, Your
for
Honor.
kind consideration of this case today.
Thank you, Your Honor. I would just request that the Isaacsons return my calls or return my letters. I represent the Olympia Yacht Club, the represented party. They know that. They should contact me.
Your Honor,
Your Honor,
that's very deceptive.
All right. That's all. All he
Your Honor,
is
we would like-
making a request. He doesn't need a response to that.
We don't have time, Your Honor. That's very prejudicial to
I
us.
understand that.
Whew. How'd y'all enjoy that? Okay, so for those of you who came in late, by no fault of your own, if you go back, I did do another commercial for y'all this week. So it's in the beginning, right after the first case. Oh, some people should be seen and not heard, but here, who cares? It's all comical to watch. It is. There, this stuff funny. So this one I think is Master Garwood is next. So we're gonna go in here. This guy. Let's just roll with it. All right. Let's go. Once again, I know I said it before. I appreciate everybody's patience. And yeah, I'm still having a good time. Just trying to make sure I navigate and take care of everybody tonight. But I'll tell you, it's not gonna happen again, huh? That's right, new commercial. You gotta go back and see it if you didn't see it. I think you saw it, Brian. I'm not sure if you was in here. But let's go.
At the jail, what is your name?
Bassam Alward.
Thank you.
You're welcome.
All right, I'm Magistrate Garwood. I'm going to be handling your case today. I'm told that you did not want to speak with the public defender.
No.
So, in this circumstance, at arraignment, everyone has the right to have counsel present to assist them for your first court appearance.
Okay, that's why I didn't need anyone to defend me, because it's my first court appearance, because there hasn't been any problems.
Okay, but it's your first court appearance, and today the court's going to advise you of your rights. I am going to go through the charges with you so you understand what you've been charged with. I'll give you your next court date. I would appoint counsel if that's something you would like the court to do. That would be at little to no expense to you. And then I have to decide what to do as far as bond and bond conditions. Conditions are things the court tells you you can and cannot do. If you violate a condition, you're subject to immediate arrest. The amount of your bond, that's whether you have to post something in order to be released. That's an evaluation I'm going to be making today.
Okay.
So are you sure you don't want to talk to Ms. Anderson? She's an attorney. She's been an attorney for a really long time. I'm guessing you're not an attorney.
No, I didn't break any laws, and I've never heard.
Well, you've been charged.
I've been charged falsely, though. I have already called the police several times and explained this whole situation. Just like Haniel has called the police and explained that I look like her ex that hit her.
Okay, so here's the thing. First, I'll advise you of your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. So you're going to want to be careful about what comments you make. Second, you have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority. In that circumstance, Ms. Anderson would assist you today, and then the public defender would be able to assist you going forward. You also have the right to a trial. At a trial, a jury or a judge would be able to decide whether you're guilty or innocent. This is case YPD 25-6642. So would you like to reconsider and speak with Ms. Anderson?
Before I make a decision, is whatever I choose, is it going to be a reason for me not to be able to go home and get out today? I understand whether I want an attorney or not.
An attorney is not going to hurt you at this point. An attorney is going to help you at this point because they understand the law and they understand the right arguments to be making regarding bond. I can tell you the prosecutors are requesting a cash bond. So they're requesting that you have to post $25,000 to be released from jail. So it's probably going to help you if you talk to the public defender. If you don't want to, I can't force you to talk to her, but she's here.
And if I don't, then I won't be able to get out without a $25,000 bond.
Well, you'll have to make your best arguments on why I should release you.
Okay.
So what do you want to do?
I'll say what I can say for it to be released. I don't need somebody else to say it for me. I mean, I know the law too.
You know the law?
Yeah, I'm not a lawyer, but I went to high school.
What?
Okay. All right. So I've advised you of your rights. The complaint in this matter alleges that on or about May 24th of 2025, that you were at 201 North Huron Street in Ypsilanti. The single charge alleges that you did make an assault or an assault and battery upon Hanel Groshusch, GrosshUESCH, an individual with whom you've had a dating relationship. That is a misdemeanor charge. It carries a maximum penalty, 93 days in jail and or $500. Do you understand what you've been charged with?
No, because this charge is false. It's not.
Okay, hold on. That's something different. Hold on. That's disagreeing with the charge. Do you understand what you've been charged with? I understand you're saying you're innocent. It wasn't you. You didn't do it. Okay. But for today's purposes, you've been charged with this crime. So do you understand what that crime is? Or do you need me to go back through it?
I understand what you said, but I'm just saying it's false.
That's fine. So you understand what you've been charged with. Do you understand the maximum penalty?
Yes.
All right. I'm going to have you stand mute. That means you'll remain silent as to the charge. I'll enter a plea of not guilty on your behalf. I'm going to schedule you for your next court date. That's going to be a pretrial that will be in person in front of Judge Barr. He will be able to see you on June 5th at 9 a.m. at the 14A2 District Court.
Yes. The problem is I still have 4 daughters and bills to pay. I need to be able to go to work. How am I gonna?
We're not there yet. I'm just giving you your court date.
Okay.
Okay. So in person at the 14A2 District Court, June 5th at 9 a.m. in front of Judge Barr. We'll send you a notice to appear at the jail. The next thing we'll need to address is bond. There are 2 parts to bond. Bond conditions, those are things the court tells you can and cannot do. If you violate a condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own or whether you'd have to post a bond in order to be released. Before I make any decisions regarding bond or bond conditions, I will hear from Ms. Landy, who I think you still need to put your appearance on the record. And then I'll be happy to hear from you. But again, I want to remind you, anything you say can be used against you and you do have the right to remain silent. Ms. Landy, your bond arguments?
Thank you, Your Honor. Ashley Landy for the people in this case. Your Honor, has the court had the opportunity the court took a swear to in this case, correct?
Yes, we did that this morning.
Thank you. Your Honor, I am requesting a cash or surety bond. I am also further, I believe, requesting a GPS. I have to pull up my notes here. In
Yes.
this case, the allegations include the defendant remaining in the victim's home, not leaving when being asked to leave, going into her bed and touching her under her clothes. The victim did not provide additional details for us to be able to look at charging a CSC in the 4th degree. However, there is sufficient evidence to charge the domestic violence, as they had previously been in a domestic relationship, a dating relationship. So I am requesting a $25,000 surety bond, as well as a GPS tether to keep him out of that 201 North Huron Street.
There has never been.
Sir, you do not get to interrupt me.
It is not your turn to talk, and
Oh.
you're not going to interrupt anybody.
Sorry.
Oh, they both jumped on him at the same time. I would just not say anything after that.
So I'm extremely concerned for her safety. This is a very disturbing fact pattern and a disturbing case. I'm also requesting that there be a prohibition against the defendant possessing firearms as a component of his bond, as well as standard supervision at community corrections. And that $25,000 cash or surety bond, I'd request it be no 10%.
Thank you. All right, now, sir, you will be able to make your bond arguments. But again, I want to remind you, anything you say can be used against you.
Oh, I want to interrupt real quick. So because I was trying to get these up and I just got back, but she said discussed in charge. So I'm going to do some history on this guy and see what the heck is going on. Because y'all know most of the videos I do, I normally try to present what's happening with it. And this guy is in weekend arraignments. I did not get the info on him, but I'm going to. And I'm going to see what's going on with him. And if I can at least follow this guy around and see what the deal is. So I know y'all will appreciate that.
Okay, I have permission to speak now?
You do.
Okay, so what I'm saying is, me and Haniel have never been in any sort of domestic violence whatsoever. Not even one time. And she's called the officers before and explained that has nothing to do with me. So because I don't understand why is all this necessary? Because the last time I called the cops and had a welfare check done on her because she wasn't answering, I was worried about her, and the cops came and arrested her. So why is all this information just gone? Nobody knows, understands. They're not helping. They just come and try to accuse us of hurting each other, but it's others that's hurting us and taking from us.
So you do have a criminal history. I mean,
No, I
what's
don't.
your date of birth?
11/12/1996. No criminal history.
So you pled guilty to an assault and battery.
Yeah, because they said I have kids and house payments and responsibilities to take care of my family. And how am I supposed to do that being in jail for months to be able to just go on trial?
Pled guilty to attempting to assault, resist, or obstruct a police officer.
Yeah, I know. I had to because I didn't need to be in jail where I can't even take care of my family.
What?
That's the reason.
I definitely got to check on this. Yeah, I missed the ball on this one. I did all this today. I gotta get on this.
Well, regardless of why you did that, you have a criminal history. That's just the fact of it.
I would never hit a woman anyways. I never said I wouldn't leave. But I said I was leaving. She's told me not to leave until you guys got there, so she knows I'll leave because other people that she's been with, because she dated several guys that look like me, because that's who's just her preference, I guess. But I've never told her I would not leave. I would not do that. I don't want to be somewhere I'm not wanted. She wanted me to come there. I said I can't stay here.
I would encourage you to stop talking. Because now you're talking about what allegedly took place on that day. If you can keep talking, but you may make the prosecutor's case for them by saying what you're saying.
I told her that I can't stay until the police come, because even if I do, they're just gonna arrest me because you already know that I'm not supposed to be here. how is she gonna, I only went there to give her money. I gave her money when I went there.
Okay, so now you've
That's
acknowledged that
insane.
you were actually at the property. So again, I'm going to encourage you to stop talking. Is there
Damn.
anything else you want to say before I proceed with your bond conditions and bond amount?
No, that's all. I was saying, I'm sorry. She probably was just having a bad day. It's not, I would never hurt her. I love her. I love her with all my heart. I care about her.
Okay.
If she's sick, I go get her medicine or ask her if she wants something that would make her feel better. Or say I'll get whatever she needs that to be happy or
Okay. I'm
I agree with that. Because the more he talked, the more is coming out. I mean, he's helping me. Eventually, I'm not going to have to do any research. I'm going to know exactly where to go with this guy.
have you stop talking, because again, you are saying things that I do not think are going to help you in this case. Your bond conditions are as follows. You're going to be required to have standard supervision at our community corrections department. That will include drug and alcohol testing. Each time that you are required to test, you'll have to bring photo ID and $12. If you don't have photo ID, then you'll be able to ask the jail for a copy of your booking photos. No alcohol, no illegal drugs, and no marijuana. Do not leave the state without prior permission of the court. Do not purchase or possess any firearms, ammunition, gun components, or any dangerous weapons, nor are you to be with anyone who has any of those items. Do you own any of those types of items?
No.
Do you understand your conditions so far?
Yes. Well,
Okay, Lone Wolf, we'll be talking because you know I'm going to get it.
am I allowed to say anything else?
I'm not done.
Oh, okay.
Do not assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. Do you understand?
Yes.
You're to have no contact with Hanal. When I say no contact, no direct or indirect contact with her, no telephone, email, texting, internet, or social media, Skype, Zoom, FaceTime, Facebook, Slack, Discord, Instagram, Snapchat, TikTok. No contact means no contact. Don't direct anyone else to be in touch with her on your behalf. Don't mail anything to her. Don't deliver anything to her. Don't have anyone else do what you're not allowed to do in reference to contact with her. Do you understand?
Yes, of course.
I never heard anybody break the list down like that. She named all the social media sites and she included mail, which nobody really do anymore. I like that. That was a good one. That was a good one.
You are not to must find another place to live, and you must notify the court of your new address within 24 hours of your release from jail. We will give you a phone number that you can contact. If you need to return to that address for a civil standby, you'll be allowed to do that. A civil standby allows you to contact the police. They would meet you there. They are there to keep the peace. That is not an opportunity for you to hang out. That's not an opportunity for you to communicate with Hanal. That's just an opportunity for you to get your things and go. Do not go without the police. Do not go to any home, temporary residence, work, school, or house of worship of Hanal. Do you understand?
Yes.
Do not violate any criminal law. You're required to appear for any and all court hearings and other places as directed by the court. All of your conditions, they will exist whether you're in custody or out of custody, and they'll remain in full force and effect until changed by the court. If there's any change to your address, email, or telephone number, you're required to notify the court. If at some point you change your mind and decide you want the public defender to assist you, you would make the judge aware of that, and then the judge can make a referral. Do you understand?
Yes, ma'am.
Do you have any questions regarding your conditions before I set the bond amount?
No, can I say one more thing?
I don't think I could stop you.
Okay, so I just want to know, so as long as I don't go there, even if she tells me to go, so then there won't be no problems between us?
You can't have contact with her. It's not
No,
just
I know, I understand, but
Perhaps.
she's the one that called me to ask me if I'm okay.
Again, I encourage you to not talk about what specifically happened on the day.
Tells me I have mail or.
See, this is a good time when having an attorney would be useful to you because you could ask those questions of your attorney.
Okay. So as of now, based on what I told you what happened, is there any way I'll be able to go home, go like to one of my relatives' house today?
So you're welcome to post the bond that I'm about to tell you about, and then you can go home to a relative's house. So this is what the court is going to do. Based upon the facts that are alleged in this case, it's of concern what was presented to the court. Potentially additional charges could be coming from how I heard the testimony. I am going to set a cash bond in this matter. That is going to be $10,000 cash or surety, no 10% privilege. I believe that is appropriate in this case.
Can it be a personal bond?
That's not a personal bond. You would have to post $10,000.
So why is
And
that?
I am going to require the defendant to have a GPS tether to make sure that he doesn't go back to that address prior
There's
to
no reason to go
release.
back to that address. I never said I wouldn't go back, not go back.
I'm going to have a GPS tether placed on you. They don't place tethers on holidays or weekends, so that tether would not be placed until Tuesday.
I just don't understand why am I being ignored? She has a mental disability.
I'm talking. I'm not sure what's so complicated.
I'm not mental health or drug addict or anything, so why are you guys saying this?
All right, I'm going to mute you if you keep interrupting me. So the tether can't be placed on the holiday or weekend. The tether would be placed on Tuesday. That's the next time the agents are here.
I have work Tuesday. Why you guys want to make me lose my job or something?
I'm not making you.
That's necessary. It's a holiday weekend.
So because it's a holiday, if somebody commits a domestic violence, it doesn't count?
If somebody makes a false accusation because I look like one of her exes, it's not up to you guys to do a proper investigation and get more proper information from both of us.
Again, an attorney would be most helpful.
Somebody that doesn't have a mental health condition.
So your bond, hey, I'm not deciding guilt or innocence. I'm just deciding what bond conditions are necessary to keep everybody safe. You've demonstrated to me an inability to control yourself because you keep interrupting me, which is rude and inappropriate in this circumstance. You did it to Ms. Londy as well. So I have to consider your ability to control yourself and follow my court orders, and that gives me concern that you can't do that either. So the bond is going to stay $10,000 cash or surety and a tether prior to release. Ms. Londy, anything further?
No, Your Honor.
All right, you're all set, sir. You can stand up and go to the door. Thank you.
He is done. Hold on. Yeah, he's done. He's done.
Okay. There's no way I get to go home unless I pay $10,000.
Right, and get the tether, and you can't get your tether till Tuesday.
So even what if I don't have $10,000 by
then you'll remain in custody until your next court date, which is June 5th at 9 a.m. So that is next week on Thursday.
And that's because I said I wasn't guilty. Well, I don't understand.
Of course not. That has nothing to do with whether you said you were guilty or not. That has to do with.
I spoke out of line, but I didn't raise my voice.
Do you want me to answer your question, or do you want to just keep interrupting me?
Nothing wrong.
Do you want me to answer your question, or are you just going to keep interrupting?
What am I interrupting? Nothing I said is stopping you from understanding my side of what's going on. Or
if every time I talk, you start
listening
talking
to you or being disrespectful or nothing. I didn't mean any disrespect towards you or anybody.
Okay, well, here's the thing. The allegations that have been presented.
I understand what you're saying, but I'm not ignoring you. I'm not trying to speak out of line.
Then why do you keep talking while I'm talking? We're done. The allegations that were presented to the court give the court concern about the safety for the victim.
What about my safety?
I'm done. We're done.
I told you guys, I had called before.
You're muted. We're muting you. You've been muted. You can go to the door. You can go to the door. We're all set.
See you.
I can't hear you. You're muted. So you can stand up and go to the door.
Bye. There you have it. This is a good one. This is a good one. So let me know if y'all interested. I'll follow up on him. Let me get his name. Lone Wolf say, we get body cam footage. I'll see what I can get. And but yeah, this guy, I like to see him in court again. So the only thing I can say, because this is the first time like I covered pro se's like this, the difference between the pro se's and the sovereign citizens, the pro se's are a little bit nicer, but they just not. I gotta be careful what I say here. They don't think about the consequences of them going pro se. I'll put it like that. I really like to say something else. It's not bad, but I'm not gonna say things on camera. So yes, all right. I see some people saying, please follow up. I like this guy. Now, if he was a sovereign citizen, oh well, I mean, they sort of had the same characteristics, just not as as aggressive, I guess. So I don't know, and I'll do this only if y'all say so. Um, if some of y'all missed the commercial, I could go back to it, or if you want to do it yourself. But if you want me to do it in here, it's probably like 40 seconds. I'll do it. If not, it's cool. We had a good long night. A lot of stuff was going on. Thank you. And it wasn't bad. Like, it wasn't a bad word. It's just like, sometimes I wish I could just be like, you know what? I talking about that guy, like, man, that was just kind of stupid what he did, like that. You know what I'm saying? But I don't know. I ain't saying it. Be my luck. Somebody come across my video, be one of the defendants, and they're like, he called me a name on YouTube. I'm not. I ain't doing it. All right, run it. Okay, I'll run it. Hold on. Let me go back. I gotta go back. Let me take it. Y'all cool with it. Y'all done seen the whole thing, most of y'all. Let me go back. And let me try to fix it here. Hold on. There we go. Oh, so fast. I'll do it right there. Hold up. And let me put myself back on. All right. So this commercial I made today is because I did Pro Se. And so it's a Pro Se firm that teaches people how to go sovereign. That's what it's all about. All right. Y'all ready? Let's do it.
I Zoom.
Okay, sounds good, Your Honor.
Anything else for this record?
No, Your Honor, thank you.
Thank you. That will conclude this hearing.
Oh, let me take myself off. I want y'all to see the whole thing. I don't need to be on there. Let me get rid of this banner. And then let me get rid of me. Are you a pro se defendant feeling overwhelmed by the legal system? Don't just represent yourself. Transform yourself with Pro Se to Sovereign, the ultimate coaching service designed to stretch your case for months or even years. Our proven system will teach you how to flood the court with 500-page jurisdictional challenges, challenge the judge's oath of office, declare yourself a secured party creditor, and reject all corporate authority by saying, I do not consent. Confuse the court, frustrate the prosecutor, and delay justice indefinitely, all while asserting your status as a private living soul of the land. Don't plead guilty, plead sovereign. Call 1-888-DRAG-IT-OUT to get your service started today. From Pro Se to Sovereign, you may not win the case, but you'll never give up your time. Live sovereign, live free. There it is. I gave it to you. That's it. That's all I got. That's what Colin say. Yo, Colin at the end, I told him I was going to tease him a little bit. It's like, that's it. That's it. I don't have nothing else. He might watch this and see me later, but I'm going to tell him I did it. So yeah, all right. I'll follow up on that guy. I'll see what's going on this week and see what sovereign citizens are in court. Got to check up into this stuff. Oh, well, thank you. You know, I try to do my best. I'm just doing it for y'all. Just add something to the content instead of just the straight videos and all that stuff. So, yeah, I appreciate it. I got more coming. Trying to work on some other stuff. As I said, I just got back. Yeah, drag it out. Oh, yeah, your God is mean. I see that you said you were late, but it's all good. I had a lot of technical issues tonight. So I hope everybody have a good night or morning, because some people are on other part of the countries that be on here. So they like in the middle of the night, 2, 3, 4 o'clock in the morning. So, okay. All right. Do me a favor, everybody. If you can, when you come out, we want to pop back in. Can y'all hit the like button for me? Because I didn't do a lot of advocating on that tonight, but if y'all could do that, I would appreciate it. Thanks for all the comments. Thanks for the patience. And I'll see you around on the next live. Okay. So a majority of y'all said it was cool to do some pro says here and there. So I'll throw them on here because there's a lot of them out there. They borderline sovereign citizens at times, but it's just something for us to watch together. Maybe I'll do those more on the live stream. So I may up the live streams a little bit, maybe throughout the week, because we normally just do like one on the weekend or something like that. But it depends on what I got, and we all hang out, okay? So thank y'all once again, and I'm out. See ya.